Intellectual rights history is a broad and complex topic, so let's approach it step by step. Thank you for subscribing to the channel. Intellectual property rights are legal protections granted to creators and inventors for their original works and ideas. These rights include patents, copyrights, trademarks, and trade secrets. The importance of intellectual rights in society cannot be overstated. They encourage innovation and creativity, protect investments in research and development, allow creators to benefit from their work, and promote the sharing of knowledge and technology. Early concepts of intellectual property can be traced back to ancient civilizations. These early ideas laid the groundwork for what would become modern intellectual property rights. In Mesopotamia, often called the cradle of civilization, we see some of the earliest examples of intellectual property concepts. Around 3200 BCE, during the early stages of the Bronze Age and the development of writing systems, potters began using distinctive symbols or designs on their ceramic vessels before firing. These potters' marks served as a kind of branding or signature for the potter or workshop that produced the item. The primary purpose of these marks was to identify the source or maker of the pottery. They also indicated a certain level of quality or craftsmanship and played a role in trade and commerce by allowing for recognition of preferred producers. Potters' marks came in various forms, including simple pictographs, geometric patterns unique to a potter or workshop, and early forms of writing as cuneiform characters developed. These marks represent one of the earliest known attempts to associate a product with its creator or origin, acting as precursors to modern trademarks and brands. Numerous examples of marked pottery have been found in archaeological excavations throughout the region, showing a consistent and widespread system. Over time, these marks became more sophisticated, sometimes including the potter's name or workshop in early writing systems. This practice spread to other crafts and regions, evolving into more complex product identification and quality assurance systems. While potters' marks were not part of a formal legal system, they served similar functions to modern trademarks, such as source identification, quality assurance, and protection of reputation. The concept of marking goods to indicate their source has persisted throughout history, evolving into modern trademark and branding practices. The potter's marks of ancient Mesopotamia represent a fascinating early example of intellectual property concepts. Though rudimentary compared to modern systems, they show that the basic ideas underlying intellectual property protection have roots in the very beginnings of civilized society. In ancient Greece, around 500 BCE, limited monopolies were granted to cooks for their unique culinary creations. This practice emerged in the city-state of Sybaris, a Greek colony in southern Italy, known for its wealth, luxury, and culinary sophistication. During this period, which marked ancient Greece's classical era, advancements in philosophy, the arts, and governance were prominent. Cooks who created unique dishes were granted exclusive rights to prepare and profit from these creations, typically for 1 year. The purpose was to encourage culinary innovation and creativity, to reward chefs for their inventions and unique recipes, and to promote the culinary arts as a respected profession. This information comes from Athenaeus, a Greek rhetorician and grammarian who lived around 200 CE. He wrote about it in his work Deipnosophistai, or the Dinner Sophists, citing earlier sources. This is one of the earliest known examples of a formalized system to protect intellectual creations, demonstrating an early understanding of limited-time monopolies similar to modern patents. It shows recognition of culinary creations as intellectual property worthy of protection. The exact process for granting these monopolies is not fully known, but it's likely that some form of demonstration or documentation of the dish's uniqueness was required. The monopoly likely covered the specific preparation method and the dish's name, though it's unclear how broadly or narrowly these rights were interpreted. Details on enforcement are scarce, but it's possible that social norms and the reputation-based economy of the time played a role. This system is similar to modern patents in providing a time-limited monopoly, and resembles modern trade secret protection for recipes, though with a formal granting process. It likely contributed to Sybaris's reputation for culinary excellence, and may have influenced the development of professional cooking as a respected art form. Much of what we know comes from later sources, so some details may be lost or altered. While this specific system didn't persist, the concept of protecting culinary creations has continued. Modern chefs often rely on trade secret protection for their recipes, and some culinary techniques have been patented. This early example from Sybaris provides a fascinating glimpse into ancient concepts of intellectual property. It shows that even in classical antiquity, there was an understanding of the value of unique intellectual creations and the need to incentivize innovation through legal protections. While quite different from modern intellectual property systems, it demonstrates that the basic principles underlying such protections have profound historical roots. Medieval guilds flourished in Europe from the 12th to the 16th centuries. They were associations of craftsmen or merchants that controlled the practice of their craft in a particular town. There were two main types of guilds: merchant guilds, which focused on trade and commerce, and craft guilds, which specialized in particular crafts such as weaving, goldsmithing, and carpentry. Guilds regulated production and trade, maintained quality standards, provided training through apprenticeship systems, and offered social and religious functions for their members. Guilds closely guarded their craft techniques and knowledge, with apprentices sworn to secrecy about guild practices. This system was an early form of trade secret protection. Guilds used marks to indicate the origin and quality of goods, functioning similarly to modern trademarks. Examples include hallmarks on precious metals and masons' marks on buildings. Guilds often held exclusive rights to practice their craft in a specific area, a form of intellectual property protection broader than modern concepts. They could fine or expel members who violated their rules and act against non-members who infringed on their monopoly. Knowledge transfer was controlled through a structured apprenticeship system, protecting trade secrets while ensuring the continuation of craft knowledge. While guilds protected traditional practices, they sometimes hindered innovation. Some guilds had processes for approving new techniques or designs. Guild practices varied across Europe with different levels of power and regulation. Italian city-states often had more advanced systems, particularly in specialized crafts. Many guilds received charters from local authorities or monarchs, codifying their monopoly rights and regulatory powers. Specific examples include the Venetian glassmakers of Murano, who had strict rules about sharing techniques, and goldsmiths, who developed intricate systems of hallmarking to ensure quality and origin. Printing guilds controlled the right to publish and distribute books in many cities. Guilds began to decline in the late medieval period due to economic changes and increased trade. However, their concepts of quality control, origin marking, and knowledge protection influenced modern IP systems. As guilds declined, state-granted patents and copyrights began to emerge. The Statute of Monopolies in England in 1624 is often seen as a turning point, shifting IP rights from guilds to individual inventors. The guild system's emphasis on quality, origin, and controlled knowledge transfer continues to influence modern IP concepts. Professional associations in many fields can be seen as modern descendants of the guild system. The medieval guild system was crucial in developing concepts that would later evolve into modern intellectual property rights. While different from today's individual-focused IP systems, guilds established the importance of protecting specialized knowledge, maintaining quality standards, and indicating the origin of goods. These concepts laid the groundwork for developing patents, trademarks, and trade secret laws in the following centuries. This video provides an overview of the history and evolution of intellectual rights. A second video will discuss the evolution of modern intellectual rights. Please click the bell for all notifications. Thank you for watching.